This is the Alternative Investing Advantage podcast from Advanta IRA, where we show you how to explore investments beyond Wall Street and open your eyes to new options for your portfolio. It's time to take control and give yourself the freedom to choose where you invest your money.
Alternative Investing Advantage podcast. My name, as always, is Alex Perny, and today we are very pleased to welcome on Garrett and Ted Sutton, attorneys at law practicing out of the state of Nevada, to cover a topic that is it's very current in the current events world, especially for people that are investing in LLCs, especially those single member people out there that were, with IRAs and other things that maybe didn't have much in the way of reporting requirements. With the Corporate Transparency Act, it's probably something that people at a high level have seen, that you now have to start disclosing the beneficial ownership interest to the IRS every year. And it has started this year. I mean, we are now ripping with everyone needing to start doing these reports. There's no kind of grace period, I don't believe, anymore. It's everyone needing, at this point in the year, having to report this stuff. So Ted and Garrett, really appreciate you being on with us today to talk about this. I'm really excited for the conversation. Maybe if you wouldn't mind giving us a little bit of background on both yourselves and your practice, and then we'll dig into the topic at hand.
Great. Well, thanks for having us on, Alex. My name is Garrett Sutton. I'm a corporate attorney here in Reno, Nevada. I became very fortunate 20 years ago to become associated with Robert Kiyosaki, the author of Rich Dad, Poor Dad. I've written a number of books in his series, including this one, Loopholes of Real Estate, as part of the Rich Dad Advisor series. So, I've traveled around the world with Robert and talked about financial education and how to protect your assets, asset protection. And fortunately had a son that wanted to become a lawyer. So I'll have Ted take over.
That's right. So I'm Ted Sutton. Obviously, I'm Garrett's son. Grew up in Reno, went to college at the University of Utah. And believe it or not, I actually got a degree in mining engineering. But the summer before I graduated, I worked at a mine in Chile. And while it was a great experience, it made me realize that mining wasn't the career path for me. So after I graduated, I decided to pivot, attend law school in the great state of Wyoming, which is great for LLCs and asset protection. Graduated there. Now I'm licensed to practice in 3 states and working alongside my dad here.
Awesome. Fantastic. It's always interesting to have a combination pair on these. And I will say it's the first father. Well, no, it's the second father and son. But the other one I did was a significantly larger age gap. It was like his 15-year-old son, but they were real estate investors. And it was kind of centered around how to, build family cohesion with, a common interest. And theirs was real estate investing. And the kid had like 3 or 4 properties, and also started doing lending out of either, whether it was his IRA or his LLCs. And it was pretty cool. So definitely cool to have on a duo, if you will. So let's kind of dig into the high level. The Corporate Transparency Act, at a very, baseline register, what exactly is it and what does it aim to accomplish?
Yeah, so the Corporate Transparency Act, it's a new federal disclosure law that requires most small businesses to report information to the federal government. So it's a very unique law of its kind because a lot of the federal laws that have been passed in the past go after the big businesses. But this law specifically targets small businesses. And what it requires small businesses to do is it requires them to report information to FinCEN, which stands for the Financial Crimes Enforcement Network. And it's a branch of the U.S. Department of the Treasury. So, when you set up a business in the past, you were only doing it at the state level. You're filing the articles with the Secretary of State. But now you're required to report this information to the federal government, too. And it has very sweeping consequences. This affects 30 million small businesses across the country, and the penalties are very severe, too. If you don't report this information, you can face penalties of $10,000 in fines or even 2 years in prison. So, it's really important that we're talking about it on the show because nobody else is talking about it right now.
Yeah, exactly. And that's one of the things that, I was excited to bring you on about, is that, we've heard a lot about it, but not a whole lot of really like specific information on, practices of this and what people can do to protect themselves. Because what a lot of people don't realize, they think it maybe just, it's another IRS reporting. FinCEN is definitely, if the IRS has no sense of humor, they might have gotten it from FinCEN. It's not a organization, especially in the area that we operate, that takes anything very lightly. So making sure that you're doing their reporting correctly is extremely important. So one thing that you mentioned to kind of start off with, you mentioned that most small businesses. So I think it's important to define the parameters of who this actually affects. So where does the kind of cutoff come? Because, large corporations, your Microsofts and everything else publicly traded, they have all the other stuff to worry about. But when you say most small businesses, could you define that a little bit?
Yeah. So in the regulations, the first question you need to ask yourself is your company a quote unquote reporting company? And a reporting company is defined as any entity that's created by filing a document with the Secretary of State. So this is most corporations, LLCs, limited partnerships. This also includes certain trusts like business trusts and statutory trusts, not revocable and irrevocable trusts, though just those trusts that are set up with the Secretary of State. Now, there are some exemptions to the reporting company requirement. There's 23 in total, and I'm not going to go through all of them. But one exemption that everyone needs to know about is called the large operating company exemption. And it has 3 requirements. And if you meet all 3 of the requirements, then you don't count as a reporting company, and you don't need to report your information to FinCEN. So they are that you employ 21 or more employees in the U.S., you have $5 million in gross receipts from the U.S. on a tax return in a given year. And then the third thing is that you have a physical office somewhere in the U.S. So, you either rent space or you own a building. And if you meet all 3 of those requirements, then you don't need to report information. But if you don't meet all 3 of them, then you count as a reporting company. And in that situation, you'd need to report. So, that threshold can be a high bar for a lot of businesses. But if you fall below it, then you're going to need to report.
Gotcha. Now, you mentioned a couple different other entities, and I want to drill down on that in a second, but would this also affect entities such as limited partnerships?
Yes. And the reason being is that when you form a limited partnership, it's created when you file a document with the Secretary of State. So it affects limited partnerships too.
Would that affect limited partnerships to the extent of needing to disclose the limited partners, or only the general partners of that organization?
So the limited partners would need to be disclosed. And this brings me into the next topic, is that you need to report beneficial ownership information too. And a beneficial owner can be either one of 2 things. It's the person who either owns 25% or more of a company. So, if you're at 25% or more, automatically you count as a beneficial owner. But the second thing is that if you exercise any quote unquote substantial control over the company, then you would count as a beneficial owner and you need to report your personal information. So,
but real quick, a limited partner who has no management control and only owns 5% of the limited partnership would not have to report.
Okay. Yeah, because specifically why I was digging into that is a lot of our clients invest in various different, the big one is commercial real estate, where that's industrial, car washes, commercial multifamily. And that would be, especially for some of the larger capital raises, when you're talking about buying a $30, $40, $50 million property, there could be a substantial amount of limited partners in that deal. Granted, if they're all just coming in at $100,000 a pop or $50,000 a pop, maybe that doesn't cross that threshold, but definitely something to be asking your general partners when you're doing your due diligence on that, if they are aware of that reporting requirement, and to make sure that you are also providing that information to them of whatever they need to report. Because it might not just be something that's gleaned off of a subscription agreement or a private placement memorandum. It might be something you need to be a little bit more coming with, especially with a new law.
Right. And so let's say the limited partners are all, you have 10 guys at 10% each. They're not going to have to report, but someone has to report on that limited partnership. And that's going to be the general partner, because they have management control. So the fact that you don't have 25% owners doesn't excuse you from reporting. You still have to report because someone has management control of that entity.
Sure. And before we kind of get into the next segment that you wanted to, I wanted to at least touch on a little bit more of the exempt organizations. You mentioned trusts, and I think a lot of people's, light bulb would be, oh, well, if it's a corporation, yeah, let's use a trust now. We'll go that route. But you mentioned a specific item in there, is that anything that is filed with a Secretary of State, basically kind of meeting that threshold. And the Secretary of State could be something different for corporations in every state. States like to be a little bit unique with what they name that. But if you file it with the state at a high level, that's kind of the general litmus for saying, yes, you need to do this report, correct?
That's correct.
And it also applies to Indian tribes, because you can have tribal nations that allow for the formation of corporations and LLCs. Mm-hmm. So it's a little wrinkle that not many people know about. But in the statute, it talks about Secretary of States and or Indian tribes.
Okay, gotcha. And so would that apply, going down the line a little bit, something that, at least again, being topical to our audience, things like statutory trusts, and it's like in the state of Florida, we have this nice little thing that people like to use called a Florida land trust. I don't know if specifically you have to file that with the state, but it's a nice little shielding anonymity thing that people can use at closing to close, investment properties with. Again, I know specifically those don't have a tax ID number. They are strictly pass-throughs. So, for things like personal property trust or like state-specific property trust, do you think those would, or would it be something you kind of have to examine and get with some counsel in that state for something that unique in that state?
Well, with the land trust, it offers no asset protection in most states, and you're going to have the land trust owned by an LLC. That LLC has to report.
Gotcha. Yeah, and that's kind of my general train of thought is that, again, I have to always disclose, I can't give tax or legal advice. And if you are in a specific state, check with an attorney local to you. But, again, different states have some, unique things like that. And again, to your point, it is basically, mainly used for anonymity purposes. You can close it in a trust, have a separate trustee, corporation owns it, and however you want to layer that onion up the chain, it's your prerogative. How much money do you want to spend, right? It's at that point, it's your choice. So again, I think that's a really important thing to hit on is that, we talk about corporate stuff. It should be more or less called like entity reporting, because it's much more encompassing that it encumbers trust, limited partnerships, LLCs. Does it also, I'm assuming LLCs, people think of LLCs, taxes LLCs, but would that also extend into like, it doesn't matter. It's like S Corp, C Corp. The taxing election doesn't offer any exemption or shielding from this?
No, every way you're taxed is you still have to report. And another little one, Alex, is homeowner associations. HOAs have to report.
Good. Maybe I try to stay pretty unopinionated on stuff, but HOAs, I'll leave it there.
We've all had experiences with them.
But the beginning of my career, I had someone that almost lost their investment property. Or a big title fight with the title insurance company for like minuscule amounts of unpaid HOA dues and some really quirky fines that they had received. And again, they wanted to come after it. They had an attorney down here that I probably built his practice on, trying to foreclose on, minuscule outstanding HOA stuff. So I've seen the teeth they can have. So maybe a little bit of transparency isn't the worst thing in that case. But again, to elucidate on that, I think, again, that's the core point and on this part of it is that, think about it as an entity. If it's not yourself personally doing something, you have an entity where that's a trust, limited partnership, an LLC, doesn't matter how it's taxed, you probably are going to fall into this. Now, from here, let's drill down a little bit because, when you look at an entity, there's several moving parts, and depending on, what part of that you are involved in, the reporting requirements might change. We talked about that a little bit to begin with. So, let's kind of talk about it from the LLC. Let's start where people are probably most viewing this from the LLC standpoint. Are there any kind of changes as to what position you might be in? Let's say something is member managed versus manager managed, versus having a, let's say an LLC or a trust as a member. What do some of those different kind of scenarios look like as far as the reporting requirements go?
Yeah, so when it comes to a member-managed LLC, that's where ownership and management are the same. So, anyone there, any member who has 25% or more ownership would automatically have to report, And then since they're all in most cases, they're all managers, all the members of that member managed LLC would most likely have to report their information. When it comes to manager managed, ownership and management are separate. So if there's any owner who has 25% or more, they'd have to report. And then any LLC manager would have quote unquote substantial control. So in that situation, they'd have to report too. And there's another thing I want to talk about trust just to clear the air, because, I did a seminar on this last month and people had questions about it. So there's some trusts that are reporting companies, such as, statutory trusts and business trusts. But other trusts, like revocable living trust, irrevocable trust, those are not reporting companies because those aren't created by filing a document with the Secretary of State. But if a trust owns 25% or more of an LLC or a corporation, then in that situation, that trust would be a beneficial owner of that entity. And, whoever has control of that trust would need to report their information to FinCEN. So in every case, the trustee of that trust would have to. The grantor would have to if they have the power to revoke it. And then beneficiaries would if they're the sole beneficiary and, they have the right to compel distribution. So I don't want to get too much into the weeds there, but, with trusts, it can get a little bit confusing. With LLCs, it's fairly straightforward.
Yeah, the only other question I would have on trusts is, and I don't know if this has necessarily been looked at, but as far as like things that become, basically, things that are used for estate planning, let's say, so something that really becomes binding on the initial grantor's death, would that in turn start causing additional reporting for people? Let's say it's reportable through the state through probate, but maybe not necessarily reportable through the Secretary of State. Would that kind of meet that litmus, or is that still something yet to be kind of examined?
I think that would have to be examined on a case-by-case basis. I think the original question is, whether the trust owns a business in a reporting company. Yeah. And if the trust either has 25% or more or substantial control.
Gotcha.
Then,
yeah, because that kind of, those kind of like odd triggers. And again, it's, not to say I'm a fan one way or another, but, I find anything with the law interesting to a point, and, just be kind of interesting to see how that plays out. Again, I think the less, the better for the most part, but again, we will certainly see. So yeah, go ahead.
One point, Alex, and that there's a little wrinkle in this. Let's say you have an LLC, you file the information. You don't have to amend that unless there's a change of ownership or your driver's license expires. So when you do this filing, you have to include an image of your driver's license or passport. And so let's say your driver's license expires in 2027. You are obligated under the Corporate Transparency Act to update that information and provide a new image of your driver's license. And a lot of people are going to forget this. That's why at Corporate Direct, we're providing a service where we're going to remind you, hey, you are getting a new driver's license this month. You need to update this information with FinCEN.
Yeah, well, that's a great point too, because most of the time, you file your taxes, you change your driver's license after you've, verified everything through e-file. I mean, who thinks to do it again for the next year? But, that's definitely, a very, very good point to make on that. Excuse me. So, the next kind of steps I think would be good to look at is, how much of the layering effect goes into this. We talked a little bit about beforehand, where people might say, okay, well, this entity could be owned by, a trust that's owned by something else. Like, how far does this arrow travel until it hits the target?
Yeah, well, that's kind of why they passed it, is because, one of the reasons was that it's hard for law enforcement to track these people down. When you have an entity owned by another entity owned by another entity owned by even another entity. So for every entity, though, you are going to need to report at minimum one beneficial owner, because then, at the top, the beneficial owner has to be an individual. So, it can be just one holding company or it could be many. So,
But Alex, they're going down the rabbit hole. They want to know ultimately at the end who is the owner.
Sure.
And
go ahead.
No, they're just going to layer by layer by layer. You're going to have to report until you get to the bottom.
Yeah, and that kind of brings up a point too, is how onerous would this be from a reporting standpoint if you do have something where it has, let's say, again, several layers to that structure, that onion, again, is, getting a little bit large. Do you have to do a separate filing for each one of those, or could you combine everything and say, hey, here's my holdings, I have here, 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 and just, kind of run down that list? Or is it something where you're going to have to basically file 7 reports with FinCEN in some cases, or maybe more?
It'll have to be 7 reports.
Mm.
So these reporting requirements are very onerous, and we've built out a Corporate Transparency Act filing department here at Corporate Direct. So, we have 4 people full time who are doing these filings for our clients or for anyone else who wants this work done. So it is very onerous, but if you don't want to do it, we'd be happy to help out.
Yeah, and to that point of how cumbersome this might be, let's talk a little bit about where it kind of meets the road here. Like, what exactly does it mean to do this? It's all well and good to understand who needs to do it, but is it just basically saying, hey, here's my little sheet of paper, okay, cool, here's who owns it? What does it look like to actually do this? Because now people, I'm sure you've had experience on actually doing this because we're past that runoff. So what's it look like to actually file that report? What's involved?
Yeah, so you need to report 3 pieces of information. So the first is the reporting company information. So this involves, the name of the company, the state where it's formed, a tax ID number, and just like a tax ID number. And then the second piece of information is the beneficial ownership information, and these are the individuals who own 25% or more or have substantial control. So in that case, you would need to report every individual who has substantial control or 25% or more.
And get a copy of their driver's license.
You need a copy of their driver's license. They need to list their residential address, and then also their name and their date of birth. And then the third piece of information is the company applicant information. But luckily, this information's only for companies formed after January 1st, 2024. And, we here at Corporate Direct would be a company applicant because we set it up. And it'd also be the people who have control of the business. And so it would be the same information as the beneficial owner, just for the company applicant. So,
but so Alex, your question is, you have to enter this information on a database, a website. Okay. So FinCEN has a website where you have to enter all this information, including giving them a copy of your driver's license or passport. And a number of people of our clients think, yeah, I can enter information into a website, and that's fine. They can do that. But a lot of them come back to us and say, I don't want to deal with this. It is a lot of work, especially if you have a company that has, let's say, 5 managers, and, instead of having one person go collect all that information, we offer a service where we'll take that agony off your plate and do it for you.
Sure. Yeah, no, that's all, great information to have, because that was kind of, you answered some of my questions of saying, is this all like pen to paper stuff? I would hope that they would have a website. Does the website at least seem to work well enough? I know government websites have maybe earned a reputation for not being the best to use.
Well, it works right now, but we think what's going to happen is there's going to be a significant backlog at the end of the year. And so in October, November, December, when all these reports come due, because if you have an entity that's set up in 2023 or earlier, you have until the end of the year to get it in. So we think what's going to happen is in the last few months, the system could be overwhelmed and maybe it'll crash. I don't know. There's been a history of that. So
I would do the reporting now.
Do it now.
If you have to do it, do it now, because by the end of the year, who knows what's going to happen to that website.
Yeah, exactly. We've seen it with, a few different ones. The ATF just had a big debacle with something new that they launched that crashed like immediately. So yeah, again, take that for what it's worth. The government, with the bandwidth and everything, if you do have to do it, I think that's a very, very clear point, is that if you know you're going to got to do it, rip the Band-Aid off. Why wait to the last minute? Now, a question at least a little bit more specific that we kind of alluded to before we were talking about before we got on the podcast was, something that's very specific to kind of our market with IRAs. We talked about a little bit about, an IRA owning an LLC for, people like to call checkbook control. Have you run across doing any reports for retirement plan owned entities yet?
I've had people ask me that question, and I think we've done a few of them, but
it hasn't been an issue. I haven't talked to anybody in our CTA department who's had a problem with it. Yeah. But, an LLC owned by an IRA, you're just going to have to capture that information and send it along.
Yeah, and certainly, absolutely. It's not the line of questions on this isn't so much of saying, hey, is this a way to get around it, but more so on like what needs to be reported. So, okay, you have to report the beneficial owner. Well, if that's an IRA, what would the custodian maybe necessarily need to do? Or would it kind of just meander through the custodian saying, hey, the IRA owner is really the one that needs to report that my IRA owns this? Or would there be something that at least, again, we as custodians would need to be aware of to make sure that, we're, if it does need to be signed off on by us or someone else like that, again, that's kind of where I was looking at it, on your thoughts on who needs to do what in that scenario.
Yeah, and that's actually a really good question. The regulations that I've read haven't really addressed this, but I do know that the regulations have addressed trust structures that own an interest in reporting companies. So in that situation, the trustee would need to report just because they have control over the trust, which owns the company. Mm-hmm. So in that case, I would think a custodian would have to report their information. And then if the beneficiary, at least in a trust, if the beneficiary is the sole beneficiary and they can compel distributions, then in that situation, they would have to report too. So, if the beneficiary of an IRA is the only person who can compel them, then in that case, they would need to report their information as well.
Yeah, exactly. And the extra nuance to that is looking at something like an ERISA qualified plan, where you have ERISA statutes that state you have to have, if you're a legally married spouse, you have to have spousal consent to compel a distribution from a plan like that. Then does that also mean that you would have to have the trustee of a 401k and the applicable spouse in a single owner entity do it? Again, I that's the world I live in, so that's where my mind goes. Again, that's definitely something that would probably need to be examined. But again, I would think, and correct me if I'm wrong, it's probably better to do the report and make a mistake than have not done it at all and say, hey, look, I did this. I made a good faith effort to do it. Tell me what I did wrong. We'll fix it next year. I would think, again, and maybe expound on that. Would you think that it's better to at least do it, take a shot at it, and then, as opposed to not having done it and waiting for clarification?
I think so. I think you want to be safe. The penalties here are pretty onerous, and we have no idea how aggressive they're going to be in enforcing these penalties. But my gosh, 2 years in prison for not filing a form. So I think the safer thing is to report and let them tell you made a mistake.
Yeah, exactly. To that point, I would think that the custodian might have to be involved tangentially. Just thinking functionally of like, if an IRA has to file a tax return, the custodian has to sign that return for like things like 990T for paying, UBIT or UDFI taxes. So I would think that maybe that would cross into this, but again, I feel like you could make an argument one way or another that's pretty compelling to say, hey, the client ultimately is just the one that needs to do it. Or saying, hey, the custodian is here. There's a reason a custodian exists for this kind of account. They need to do it too. So yeah, it's going to be something to definitely look out for. Now, let's also, again, it's important to understand the ramifications of not doing this. So getting into a little bit of that, have they kind of delineated past just the standard monetary penalty and also the potential incarceration penalties? Have they given kind of a sliding scale, or is it just kind of X, Y, and Z so far?
We don't know how they're going to handle this. Typically the government likes to make an example of someone to get everybody else to comply. And so I would think that, there's going to be some, anti-government person up in Idaho who is going to say, I'm not giving the government any of this information. They'll go after that person. And people are going to make mistakes with this. Is it a willful violation? If you make a mistake, it's kind of a confusing law. So I don't see them going after people for the $10,000 penalty who just make an innocent mistake. But for people who willfully violate this, they're going to make an example of someone.
Sure, absolutely. I think, it's what's the parable, the protruding nail gets hammered.
Yeah.
Try not to be that nail in this scenario, especially if the government's the one swinging the hammer. Maybe
Yeah.
to that point. So, excuse me, man, it's okay. So from here, looking at it, I think, again, the primary concern with a lot of people is privacy. And I think everyone should be concerned about privacy. It's, you wouldn't just walk around with your social security number tattooed on your shirt. So, why should you give out more information than you absolutely need to? But especially when it comes to things, we've been talking about trust and, anonymity and corporate structures. Those things, again, play into a want, and I would wager to say a need for privacy. So again, with states such as Florida, there's not a whole lot of anonymity for your LLC. I mean, you could structure it, yes, where you have other people stepping in, but you can get a lot of information on the division of corporations in Florida to the point where you can, not too terribly difficult, and there's been a lot of problems with Florida specifically in going in and changing corporate information for people. It's pretty readily available in the state as compared to states like, let's say, Ohio or Wyoming or Nevada, where there's a lot more shielding of saying, hey, you can't just go to the state and be like, okay, let me look up everything about this company. How public is this information going to be?
Yeah, so there has been misconceptions out there that this database that FinCEN runs will be available to the public. It's not going to be. So it's only going to be accessible to certain law enforcement agencies as well as the Department of the Treasury. But, unfortunately, while it's not available to the public, it is a very target-rich database that hackers are going to go after, no question about it. So, we've seen these leaks from other government agencies in the past. And so while it is private, I am very concerned that, the database could very easily be hacked in the future.
Well, and, people say that the IRS returns are confidential, and for the most part they are. But someone from the IRS leaked taxpayer information to ProPublica, and they haven't done anything against this leaker. So people are rightfully concerned that the IRS database can be hacked. So, we're going to see how this plays out. The penalties for hacking the FinCEN database are $50,000 and 5 years in prison. Now, that's great, but how often does a hacker ever get caught? I mean, when have you ever heard of someone who hacks a government database ever being brought to justice? So,
Yeah.
like Ted, I worry that this is a target-rich database that is going to attract every hacker on earth to try and get through.
Yeah, especially. And, the other thing to kind of look at, too, is it's not just the government database, but especially in, corporations like yourself have to be very concerned about that, because if you're handling a large influx of this, the information is being born from a lot of different places. I think, again, to your point, how onerous this is for individuals, a lot of business opportunity will crop up for people to provide this service, to people. And then also, again, it's not just, you giving the information to the government. There's a lot of different pockets where this information can be. And the larger the firm that handles this, the more information they have. So maybe the hacker doesn't go after the government, but they go after the H&R Block that's handling it, or, someone to that effect. So again, there certainly is concerns there. I think rightfully so that people should definitely be looking at that. And any other points on that before we kind of migrate a little bit?
Well, I just think that your concerns are genuine and worthy. I mean, anytime the government gets the database together, it's been hacked. The SolarWinds hack. It was kind of funny, Alex. The SolarWinds hack occurred with 16 government agencies. all sorts of confidential data was released. And the same week of this incredibly huge hack was the same week that the Treasury Department came out and said, our FinCEN database will never be hacked. It was in the same week that the government was hacked that they claimed they would never be hacked. And so, I just think that you have to be cautious, but at the same time, the penalties are onerous, and you've got to give up this information. Will the law be repealed? Perhaps. But, there were a number of Republican senators who were behind this law. This law had bipartisan support. And it seems like that the people in Washington want to have greater information about all this.
Yeah, absolutely. And to that point, do you feel that there's any concerns, at least right now, with again, the point that a lot of people like to use LLCs and corporate structures for is asset protection. Whether or not the person actually really needs asset protection is, always a question. But the point of, especially for larger, corporations, maybe where, you have employees and some, other things going on, not just maybe your single member LLC for the rental property. Are there any concerns that you're at least seeing that might play into some asset protection for this new reporting requirement?
Well, I think that there could be some people who don't want to set up LLCs and corporations. They're not going to want to set up businesses that are created when you file a document with the Secretary of State. But we don't recommend that just because you face unlimited liability if you get sued. So if you operate as a sole proprietor or a general partner, then you and your partners are on the hook for everything. So I could see in the next few years a push for people to start using that just because of the CTA. But, I think the burden there outweighs the benefits.
For me, the greater concern is our litigious society. Yes, there is a problem with this database. It may get hacked. But I think a much greater problem is our litigious society. Every third billboard is for an attorney wanting to sue someone.
Yeah, exactly.
You need to take steps to protect yourself against that. That's a bigger worry than the CTA.
Yeah, and with the pace that tort reform goes at in the United States, nothing's really going to change probably very quickly at all. We just had a relatively large reform in Florida, but it brought the personal injury case threshold from 5 to 2 years. It's not like this stuff is really being reined in to a meaningful degree. So, again, having this maybe push people away from structures that do inherently offer asset protection to other things would be something to wait and see for. It definitely is. And that's kind of part of the issue with this is there's a good amount of wait and see. At least there is a significant amount of information out there from the RIP that says, hey, here's what we need to do. But, especially for a lot of our clients, there's some unknowns there. It's not as clear for something, for businesses like us that, have that, we act in a custodial capacity to assets and stuff like that, where does that burden lie? So with that said, that's kind of, at least on the top of my head, most of the questions that I had on this. Are there some other salient points that you really want to cover when it comes to this topic that we haven't really touched on yet?
Yeah, one thing is that Ted mentioned briefly that if you have an entity that was formed in 2023 or earlier, you have until December 31st to file. If you form an entity this year, you've got 90 days to get the information in. So if you're forming an LLC now, don't think you have until December to file. You've got 90 days to file. And then in 2025, it'll be 30 days that you have to file. And for a lot of syndicators, you're going to set up the limited partnership or the LLC, and you're not going to know who's going to be an investor quite yet. So what you're going to have to do is file that information within the 30-day period. And then as you bring in investors, you're going to have to amend the filing to reflect who the beneficial owners are.
And is there a mechanism for amendments to this?
You can just go online and amend it.
Okay, so what I was kind of getting at was saying, do you have to refile, or can you just go into the same one and be like, hey, we have an amended member or substantial shareholder?
Yeah, so you would file an amended report within 30 days after the change. So if you bring somebody else on board who, meets the 25% requirement or the substantial control, then you just file an amended report with FinCEN within 30 days from that change.
Yeah, and that also brings up the point of the government getting a lot of information about, private corporate transactions, because with the exception of, again, those larger entities, this really kind of focuses, again, what was it, like $5 million in gross revenues, 25 employees, and what was the last one?
Yeah, so it was 21 employees, 5 million in gross receipts, and then having a physical location, physical office that you own or rent in the U.S.
Yeah, and again, especially from thinking just from the perspective of like larger startup companies, even if you're raising $20 million of capital and you have everything else, if you don't have, well, could you say a capital raising is a gross receipt, like selling stock would be a gross
So if
receipt?
you're starting out, you can't prove that you have 5 million in revenue, even though you brought in 12. Yeah, even though you brought in 20 million. So you start out a business, you raise a bunch of money right at the start. You have a lot of employees at the start, but you can't prove you had $5 million in revenues because you just started.
Yeah.
So you have to file.
Yeah.
So there's one other thing, Alex, and that is that FinCEN has a proposed rule where they want registered investment advisors to report the same information on all of their clients. So there's going to be a Corporate Transparency Act for registered investment advisors. At least that's proposed. And that is going to put a huge burden on people in the financial industry.
Sure. Yeah, absolutely. That's one yeah, I had no idea about that part of it, and definitely see where that fleshes out. But I can only imagine how cumbersome that would be for RIAs out there that are, just operating a normal course of business, now having to disclose their whole client database to the government. Which, I mean, again, it's the government has that information in some forms and fashions when they have to do their FINRA registrations, and if they're, selling investment products and, underneath their brokerage umbrellas, and if they have IRAs and different stuff, there's other places the information is out there. But the fact that it's kind of so not to be a pun, but so transparent at this point, again, is definitely something that people should keep an eye on, whether you're concerned about it or not. It's at least good information to be abreast of.
Definitely. The fact is nobody's talking about it, and the penalties are severe. And as we just mentioned, the CTA could very easily be the tip of the iceberg, just because you see all these other regulations that FinCEN's going to release, and I don't know where they're going to stop.
Well, and I'm surprised that there hasn't been more of an uproar, and maybe that's why the government is not promoting or letting people know about this. Is I would have expected a huge uproar. 30 years ago, people would have been up in arms that the government is demanding this information, and maybe our society's changed. But
yeah, I think, at least from my perspective, I think it's just people not realizing the scope of it. Especially if, again, you just run you have, let's say it's a husband and wife, or just a couple partners in a small LLC, and you own $500,000 worth of real estate, right? You're so used to being so small that who cares? Or if you're just a single member LLC, selling widgets on eBay or something, just, again, you hear Corporate Transparency Act and it's like, oh yeah, corporate. You're thinking, Microsoft, IBM, all this. You're like, it just doesn't apply to me. And that's why, again, it's so important to have avenues like this where we can get that information out to the masses, where hopefully, that T+1 of it spreading through the populace is very important. So again, I really do appreciate both of you being on. Any final points? So we're pretty much covered. I think we pretty much covered everything that I wanted to. Any final points that either of you would like to cover before we button this up?
Well, we offer a free 15-minute consultation with an incorporating specialist. If you need help with the CTA, if you need to set up an entity, an LLC or corporation in all 50 states, we at Corporate Direct are happy to help. And you can go to our website, corporatedirect.com, and set up a free 15-minute consultation.
Fantastic.
Another place you can find us is on YouTube. So if you go to YouTube, type Corporate Direct into the address bar, you'll see our channel. I post videos there once a week. And I've done about a dozen or so videos on the Corporate Transparency Act, as well as a bunch of others on asset protection. So, we have articles on our website, but if you like watching videos on this stuff, you can head over to our YouTube channel. And I'd appreciate the subscription and the like and everything. So
no, absolutely. We always want to make sure we highlight guests and what they have going on. To that point as well, can you do CTA work for any corporations in any of the 50 states?
Yes.
Yeah.
Okay, gotcha. Yeah. That's important.
We want to be your registered agent so we can keep you updated. So if you come to us for the CTA work, we're going to ask to be your registered agent in the state of your incorporation and the state you do business in.
Okay, fantastic. Well, again, I really appreciate you being on with us today. The most valuable asset we all have is our time because we can't make any more of it. So thanks for carving out some time for us and our listeners today. With that said, thank you very much for being on. This has been another edition of the Alternative Investing Advantage podcast. My name is Alex Perny, and we'll catch you on the next one.
Thank you for tuning in to the Alternative Investing Advantage podcast. Tune in next week for more investing tips and strategies.
Want to hear more episodes of the Alternative Investing Advantage? Search podcast at advantaira.com and subscribe.